Welcome back to the Law Stash channel. My name is Anton Vieltsin and I'm a criminal defense attorney in the Southern District of California. Once in a while I read a case where the facts just seem too bizarre to be true. In this situation, an individual is taken out of his home at gunpoint for no apparent reason, and then the officers later go into his home to find some evidence of a crime. In this video, we'll focus on attenuation doctrine, and I'll explain after this. In this video, we'll be discussing United States versus Javier Garcia, which is a 2020 case from 9th Circuit. As always, I will first discuss the facts of the case with you, and then we'll talk about the law. Now, in this case, the facts are critical. Pay close attention to what happens. We have a suspect running away from the police, and the police are chasing him. Now, this individual runs into Mr. Garcia's apartment, and then the police, rather than running through the apartment, one officer stands in the front door, and then another officer runs towards the back around the apartment and waits for that suspect to run through the back door. Rather than doing that, the suspect jumps out of the window and escapes. Seconds later, the officers apprehend that suspect. The next thing that happens is truly bizarre. They now have the suspect in custody, but they make a decision to enter Mr. Garcia's apartment anyway to check for injured individuals and to do a protective sweep. Now, with guns drawn, they enter the apartment. Garcia walks out of the bathroom and he says that he was sleeping. Now, the officers say that he has marks on his face consistent with somebody who just got out of bed. You would think that this is where it ends, but no. The officers then handcuff Mr. Garcia, they take him outside of his home, and then they do a records check. Turns out Mr. Garcia is on federal supervised release. Now, if you ever had a criminal record in federal court, chances are the judge also sentenced you to supervised release, meaning that there's conditions under which you have to live. Most of the time, you give up your Fourth Amendment rights. And so in this situation, Mr. Garcia, because he's on supervised release, gave up his right to Fourth Amendment. So the officers can then go into his apartment to search it. And so that's exactly what they do. The officers re-enter Mr. Garcia's home under the supervised conditions, release conditions. And what do they find? They find methamphetamine. He's charged with possession with intent to distribute methamphetamine under 21 U.S.C. 841. He's then questioned by the police, and he confesses that it was his methamphetamine in the apartment. Now, at trial or before trial, he files a motion to suppress 1, the methamphetamine, and 2, statements made by him after he was arrested. Here's what he argues. He says that the first entry into the home was an illegal entry. Under the Fourth Amendment, you have a right for the officers to get a warrant prior to entering your home. And in this situation, they didn't have that warrant. And remember, at that moment, they also didn't know that he's on supervised release. So what is the justification for them entering that apartment?
Here is a bulletin from Channel 5 News.
Hey, sorry to interrupt our discussion, but can you do me a huge favor? Can you be a friend? Click that like and subscribe button. It really helps me out. And if you can, share my videos with your friends on Facebook. That also helps. So let's go back to the video. Well, the officers say it is the exigent circumstances or an emergency aid exception. Under this exception, the officers can go into the apartment because there's some exigency. But in this situation, on his first appeal, the Ninth Circuit made a decision that this was not an exigent circumstances situation. After all, the suspect was apprehended. So why are you doing a protective sweep of the apartment? You're no longer looking for anyone. And then the other issue, giving somebody help or aid, who are you trying to help? You're not even sure who's inside that apartment. So why are you entering it? Because of that, the exclusionary rule should apply, and you would think that everything that follows from that illegal entry into the home should be suppressed. That is exactly what exclusionary rule means. All seized evidence and all the derived evidence should be suppressed. That derived evidence should be suppressed under what's called fruits of the poisonous tree doctrine. So anything that follows should be suppressed. But not so fast. When the case gets remanded back to trial court, the district court says that there's an exception to the exception. Under the exclusionary rule exception, we have attenuation doctrine. Under this doctrine, certain evidence still comes in. And so the court says that the evidence that followed comes in because between the first search, the first entry into the home, and then the second, we have the evidence. We find out that Mr. Garcia has supervised release conditions. Now we get to the Ninth Circuit, again for the second time, and first we have to discuss what's attenuation doctrine. Well, it applies when the connection between illegality and challenged evidence has become so attenuated as to dissipate the taint caused by illegality. Meaning that what happened with illegality versus what we find later, we have some intervening situation happening. In this case, it is that knowledge about supervised release conditions. But we have a horrible case, Utah versus Strife, that was decided by the Supreme Court several years ago. In that case, an individual was stopped on the street. He was searched, and that was an illegal search. But the court said that the officers later found out that this individual had an outstanding warrant. And so even though the officer made an illegal act first, then he found out that the individual had a warrant, and because of that warrant, he was able to arrest him and search him. And so the Supreme Court said it doesn't matter that it's reversed. Under the attenuation doctrine, that evidence still comes in. So we have to look at three factors. First, the temporal proximity, the intervening circumstances themselves, and the purpose and flagrancy of the police officers. So let's talk about that, and let's talk about Strife as well. First, the Ninth Circuit talks about temporal proximity. Here the government concedes that this factor really leans the scales towards suppression. Why? Well, because we have only a few minutes between the first entry into the home and the second entry of the home. Just a few seconds passed, or minutes passed, for the officers to find out that there's a supervised release condition. And the government concedes that. The second factor is intervening circumstances. Here, the difference between Strife and this case is that in Strife, the Supreme Court case, we had a warrant. A warrant is issued by a magistrate judge, meaning that a judge made a decision for that person to be arrested. The officer is simply executing that warrant. He's not making that decision. And the Ninth Circuit says, here we have supervised release conditions. They don't require the officer to actually arrest or search an individual. They just give discretion to the officers to do so. That is the big difference. And so the intervening circumstances here, the supervised release, again leans us towards suppression. And finally, the purpose and flagrancy of the conduct. Well, the huge difference here is that the search here was of a home. Home is explicitly listed in the Constitution. It perhaps gives you the most protections. And in fact, the Ninth Circuit says that intrusions of this nature can have tragic results. Of course they can. If somebody enters into your home without any warning, without telling you that they're police, well, you can shoot back. You might try to do self-defense. You might attack a person without knowing that they're police officers. So there could be tragic results. The difference here is that this was a home. And in Strife, we're talking about somebody being stopped on the street. So again, this factor leans us towards suppression. So the Ninth Circuit says that attenuation doctrine does not apply. The evidence, the meth found, and his statements, Mr. Garcia's statements, should be suppressed as fruits of the poisonous tree under the exclusionary rule. If you enjoyed this video, if you now understand how exclusionary rule applies and the exception of attenuation doctrine applies to that exclusionary rule, click like and subscribe to my channel. Thanks for watching.